Good morning or very early afternoon, no matter where you are. Welcome to Fisher Phillips Privageo and Vault Verify's 7 ways to future-proof your employee data privacy approach for CPRA and beyond. We're going to give the many folks that have been joining this webinar just a couple of 30 seconds to join in, having started right on time. And I will wait for them just for a second before introducing the day. To give you a sense of what we will be covering, we're going to be doing a quick review of the new laws impacting employment data privacy. We're going to clarify the employment data challenge and the data itself for you. We're going to review a streamlined approach. If you're behind or in the middle of this process, we hope you find that valuable, sort of an aggregated consensus of what best practice is. And maybe most importantly, we're going to start unpacking and discussing the challenges of managing third-party data and the nuances surrounding it. We've got quite a bit of discussion. For those of you just joining, I am going to be looking at the questions that you provide. So please provide that, but be aware that we may not be able to cover. We'll try to get to your questions as quickly as we can. Otherwise, we'll save them for the end if we have additional time. Without further ado, thank you for joining us. My name is Brad Kelso. I'm going to be a moderator for today. And I am joined by my esteemed colleagues, Usama Koff, the partner at Fisher Phillips, Bill Roy, president at Vault Verify, Steve Curler, co-founder of Privageo and Privageo, and me, the moderator, Brad Kelso, also co-founder of Privageo and Privageo. Usama, you want to say hello and introduce yourself?
Hi, everybody. I'm the co-chair of the firm's Data Security and Workplace Privacy Practice Group, and I work with clients on CCPA and CPRA compliance, as well as tackling any kind of other data privacy compliance, state or federal, as well as dealing with data breaches, ransomware attacks, etc. All of the above. It's my pleasure to be here, especially with an esteemed panel of experts.
Thanks, Usama. Bill, say hello.
Yeah, thank you, and good day, everyone. I'm Bill Roy, president and co-founder of Vault Verify. We're thrilled to be here today with all of you. I like to say that we started Vault Verify to be different from the beginning, to protect data and employee data privacy before it became fancy. And that's our goal for you today.
Well, it became fancy quick, didn't it, Bill? Steve?
Overnight, it did.
Yeah, sure did. Hi, I'm Steve Curler. I am a co-founder of Privageo. We are a data privacy and cybersecurity consulting firm. So we take the wonderful advice that attorneys like Usama give clients, and we help put it into action by operationalizing it, both on the privacy and cybersecurity side. And I'm here with my partner, Brad Kelso. Brad, why don't you talk a little bit about yourself and Privageo?
Privageo is a nonprofit. We started it when we started Privageo, and it grew into about 1,000 members nationwide. In fact, internationally, it provides data and brings people together to talk about the privacy and security challenges. And we've had a number of webinars and have been very appreciative of Fisher Phillips' involvement in that quest as well. But without further ado, I think it's important for us to get a little foundation on the background of the laws impacting employment before we dive into the subtleties. Usama, what can we learn about the legal landscape out there?
It's a patchwork of laws. That's the legal landscape. We have seen a trend that started internationally in other countries, Europe with GDPR, back several years ago when it was implemented. And California then led the way with its own law that was passed in 2018, very comprehensive, broad, comprehensive consumer privacy law. And then we have several states that have followed suit. We have 4 states that have enacted a law like it, Colorado, Connecticut, Virginia, Utah. And we have anywhere from 10 to 20 other states that are in the process of or have attempted to pass a law like it. And then we have a federal bill that has been proposed and multiple different federal regulations pertaining to certain industries or certain types of records, like health records, financial records, etc. So at the end of the day, we have a patchwork of various laws, which makes it very challenging for any company to comply.
So if you're simplifying it, what would you say to folks thinking about the way the law is written? I know there are a lot of characteristics.
All of these consumer privacy laws that tend to be passed or are in the process of being passed in different jurisdictions, I think really come down to some of these fair privacy or fair information practices, FIPS. But the three main objectives of all of these laws are, number one, notice and transparency. It's to make sure that people understand what data you are collecting about them, when you're collecting it, and how you're going to use it. It's that idea that that consumers don't even know anymore what data is being collected, right? So it's creating that transparency. So a lot of the requirements of all of these laws tend to fall into this bucket. The second component or objective of consumer privacy law is to give consumers control back. There's been a sense of the loss of control over our data as individual consumers. And as a result of that, these laws tend to try to give back that control to consumers in the form of certain rights that consumers have to find out certain things about their data, to limit use of their data, to correct their data, or to get their data deleted. The third component or objective of all these laws is to go beyond giving control back and also to regulate how businesses collect, disclose, use, sell, share, or retain data. So a lot of the regulations and rules within these laws tend to focus on that. What are you supposed to do as a business with respect to personal information? How do you collect it? How do you, what are the limitations on disclosing it? How do you use it, etc. So this is sort of the elevator speech for what is the consumer privacy law? What is this all about? It's really these three things. Everything we're going to talk about fits within one of those three objectives.
So let's talk about the consumers impacted, certainly in California. When we define consumers, who are we talking about and how are we defining them?
That's a foundational question, right? So who is our consumer? A lot of times I get companies that say, well, we're not a B2C company, we're just a B2B company. And so there's this misconception that the law doesn't apply to them. Well, the California law, the California Consumer Privacy Act, defines consumers as anybody who's a California resident, period. Who is a California resident? It's someone who has spent more than 6 out of the last 12 months, not necessarily consecutively, in the state of California. And there are other potential definitions for who's a resident. But this is an expansive definition. It applies to anybody who visits your website, for example. It applies to now, starting in January, it's going to apply as far as almost all of the requirements that previously never applied. It's going to start applying to job applicants, employees, retirees, independent contractors, family members and beneficiaries, children of your employees whose data you collect in the course of employing the employee. Those are now consumers. And it's also going to apply to individuals in the B2B context that you deal with. So representatives of your vendors, of your corporate customers, of any other entity that you deal with in a commercial business setting, the individuals in that context, you're collecting data about them, and those are considered consumers. So it's a very broad definition, which makes it very challenging here to address. And so we're going to focus in this presentation on the HR side of things. Employment-related consumers are your current and former employees, your job applicants, your independent contractors, and your family members and beneficiaries of your employees.
Brad, if I might just interject a little bit, I think what Usama just shared is really, really important, but it's from a legal perspective, right? Let me talk a little bit and maybe just share some thoughts about when we leave work, while we're doing our wearing our hat, our title at work, when we go out and we go back home again, we're all consumers and we're all employees, right? And the data and if you think about it in your own life, you've signed up for apps, you've signed up for all kinds of services online. Your data has been shared everywhere, and not just with the company you're with, but broadly shared, so that your companies are able to actually know more about you than you know about yourself. I think one stat during a recent case was that Facebook had 5,000 data points on every American. I don't have 5,000 data points on me, right? So consumers are basically getting a little bit nervous about all of this. And this is what the laws are about. They're basically trying to say, hey, hold on, we've got to get this transparency. We've got to get this consent. We've got to give consumers some sense of control over data, and the same as with employees. And if you look at the trends, really, what we're seeing is that consumers are starting to make decisions about where they shop and where they do business based upon how well they can trust you with their data. If anybody's been out there looking at ads, look at Apple's ads. We'll never sell your data, right? Look at the big billboards out there for use the alternative browser, the DuckDuckGo, the privacy browser, right? Look at what Microsoft, Cisco are messaging and saying, we won't sell your data. So there's a trend here that's happening. And it's also going to happen in my belief, with employees. In this day and age, when it's difficult to attract good talent, culture is a very important thing. And if you can convey the message that says, we're on top of it, we understand what data we collect, here's why we collect it, we're going to be good stewards of that data, I think you start to embody a really positive culture. And that's what companies are doing on the employment side, but also doing on the broader consumer side. So I know it's oftentimes we think about these laws and say, oh my God, look at another regulation being passed, now I got more work to do. But on the flip side, put the other hat on and say, how would you like to be treated if you were that consumer or employee? And I think the laws, while not perfect, are directionally trying to help set the tone for that kind of a new stage, if you will. And I think that's just an important distinction to make here. So sorry for interrupting, but.
No, great note.
Great point.
Think about the largest market capitalization companies in the world. They are making money, and their foundation is our data. So your 5,000 data points, and I agree, Steve, I can only come up with 7 data points on you. But the other 4,973, somebody's got them, and they're serving information. So great segue. Usama, what kind of information are we talking about here?
It's much broader than what you would consider PII, personally identifiable information. And I would caution people to start moving away from using that terminology with respect to complying with the CCPA and any other consumer privacy law. Because the term PII is very limited as defined by other laws. So what is personal information under this under the California law? Under the California law, it is any information that can reasonably be used to identify or be linked to an individual directly or indirectly, which means it doesn't matter whether you yourself can identify the individual with the data points you have on them. It's about whether those data points that you've collected can reasonably be used to associate with other data or be linked to other data to identify the individual. So it's very broad. What is not covered here is publicly available information that has been lawfully made available from government sources and other public sources. However, information that an individual posts on their own private Facebook account that they didn't share with the rest of the world, they only shared with their friends, that's still private. Right, so it doesn't make it necessarily publicly available. So in the employment context, it goes beyond data that is typically housed by HR, which really makes this not an HR problem per se. It's a company-wide issue. Employment data is collected and used by every department and is not just maintained by HR. Some of this data is maintained by HR, and HR would be the subject matter experts on, but some you would have to go outside of the HR department to learn about. What is changing on January 1st, 2023? as far as the definition, because this definition has been in effect since the CCPA took effect in 2020. But in 2023, we're going to have this subcategory called sensitive personal information. And sensitive personal information includes a number of different things. You can guess the most expected ones, like health information, biometric data is going to be sensitive, social security numbers, state identification numbers, those are going to be sensitive. But there are also other categories to consider within that, such as your precise geolocation. It also includes the contents of personal communications for which the business is not the intended recipient. So personal emails that or personal text messages that your employee receives on a company device or a company email, those may contain sensitive personal information if the company is not the intended business recipient. And there are others that are included through this definition. And this highlights the need for some of the things we're going to talk about here today, which is you got to really understand your data. On the next slide, we have visualized for you an example. So let's just take your employees, current employees, to be specific. For a current employee, typically you are collecting, creating, receiving data about an employee in a variety of ways from many different places that can fit into one of these categories. And there could be more. These are just examples. So you have your typical personal identifiers, contact information, etc. You have this large bucket of employment information that can probably be subdivided into many categories, like information related to their performance, information related to attendance and payroll, and so on. You also have this category called inferences. Inferences is an interesting one. It means that you have taken all of the other data you have collected and used it to create information about the individual related to their characteristics, predispositions, profile, attitudes, etc., which frankly every employer is doing about all their employees and job applicants. You're creating inferences to make decisions about those individuals based on the information you have. So inferences is a very important one. And then we also have this pay data as an example. It may not necessarily be its own category, but this is an example we want to highlight because it's important for you to understand what is happening with that information, how is it being shared, etc. Learning what information you collect also means you have to learn what information you have hired a vendor to collect. And that's going to be a very important part of our discussion, is that this is not just about the information you directly possess, but it's any information about employees that you have hired a vendor to collect or retain on your behalf.
I would be remiss if I didn't ask you the question at the bottom of family dependents. I've got my children on life insurance and other beneficiaries. Does the California AG care more or less about children or minors broadly?
It's definitely a priority, and so policies and procedures related to protecting the data of minors has always been a top priority for regulators. So I would pay extra attention to that category of data.
Right, Steve. I'm already overwhelmed if I'm the director of HR. Goodness, please help me understand sort of the challenges and how to unpack this.
Well, HR is pretty unique, Brad, and we've done a number of clients where we've inventoried or looked at how HR organizations are using personal data. And a couple of things that are a little bit unique about employment data versus other consumer data from what we've seen. First of all, the uses are extremely broad. Osama just showed a slide of the bubbles. You can just imagine all the different places that you'd be keeping employment data. Everything from time cards to job applications to various benefit forms that you'd fill out to payroll information. It really is quite broad. In fact, when we do this, we see typically even a small company, the lowest we've ever seen is 42 different data sources where employment data sits. And just think about that. That's quite a bit. In fact, we just finished a client last week, and right now they hold the record at 96 data sources. But average, it's going to be about 60, 65 data sources in most companies. By the way, it's not just size. Yes, the one that had 96 was a fairly large client. but the one that had the previous record at 86 was a small manufacturing company, right? So it's not even size oriented. The point is it's a very, very broad range of data. And I'm not talking down to the record level. I'm talking down to the data source level, right? A data asset inventory is pretty broad. So a lot of data, very broad, and a lot of sources around it.
Yeah, Steve, tell me it's not including my hard copy files on the back drawers.
Oh, it sure is, Brad, because that data in your file cabinet counts as much as that data that might be capturing an employee on a video camera, right? As much as it counts for that thumbprint that you might be using or so on your badges when you badge in and out. So it's really quite broad, and it's all included. The law doesn't care, right? It's personal data no matter what form. And that brings up a good point, Steve, right? Because, yep.
I was just going to add there, as you guys look at working with clients, I'm sure you see the same thing we do, that it's become kind of commonplace to send a whole file, regardless of whether that vendor really needs some subset of that, but to send all of the data. Well, there are vendors, so we're just going to send it, whether it's necessary or not. And I think that's one of the unique challenges within this HR space. Would you agree?
Absolutely. Very, very much. We've never, I've been in IT for more years than I want to tell you, and we've been trying to get our arms around data and data minimization for ages, right? And with disk space so cheap, we've gotten, frankly, quite sloppy about it, and we just share data freely. And it is in large files. We don't really filter it out. We don't minimize. It's just kind of where things are going. And you're absolutely right, Bill. We do share. I see an awful lot of sharing of not just what you need to, but entire lists. And it's as simple as one client recently was. I think their program was Weight Watchers. They had to deal with Weight Watchers, and they said, great, let me send you my entire employee list with all their contact information so that when they come down, you can check them off and see if they're really an employee, right? And they're not really thinking about the fact that they've just, handed a whole set of data over to somebody. Now, granted, it's a name and a contact information. At that point, it's not social security numbers and things. But the mindset is to share everything, not just share what's absolutely needed. So totally right, Bill.
I also have another comment. So all these things that just Steve just went over as the challenges that are unique to HR as far as data privacy and compliance really highlight the fact that your plan to comply with respect to customer data and on the customer side of things, if you're if you're subject to this law, is not going to be the same plan, or it is not going to necessarily translate the same to the employment data side of things. And you need to you need to understand these complexities related to employee data and employee vendor relations and things along those lines to tailor the specific action items and the specific plan to get your company into compliance. So I think that's the my conclusion out of everything that Steve said is whatever plan you had on the customer side of compliance, it's not going to necessarily work for HR data.
Sounds like it's important to get busy, Steve. If I need to streamline this thing, take us through sort of getting compliant in a more streamlined approach, if you would.
Well, you can't start data privacy project without having a data inventory. It's so foundational. So you've got to understand where your data is for lots and lots of reasons. We can get into here, but number one, get a data inventory that's robust. I suggest starting with a data asset inventory, not one that goes to the field level, but just get a sense of where the major data stores are, and that's back to the point I mentioned earlier. Secondly, you've got to secure the data. Once you know where your data is and you've kind of got a sense of where it is, you want to know how to classify it. Is it really sensitive, somewhat sensitive, highly sensitive? Because once you've sort of identified where the most sensitive data is, you want to appropriately secure that data. I think thirdly on the list, especially in HR, you share so much data via third parties, right? And we want to talk some more about that in a minute. But that sharing, you're really relying on that vendor to also treat that data with the same respect and care that you are. So managing your third parties, minimizing what you're sharing, protecting what you're sharing, and making sure that they have an appropriate response in the event of a breach or so on is essential. You've got to, by law now, and Osama will fill you in, you've got to provide notices at time of collection. So every time you collect personal data, you've got to get your notices of collection together and your privacy policies that reflect what data you're collecting, why you're collecting it, and what you're intending to do with it. Your consumers, your employees are now consumers. Just like consumers, they have a right to submit a request and say, what information do you have about me? How are you using it? Who are you sharing with it with? How long do you intend to keep it, right? And you've got to have responses for some of those questions. So another important piece that leads into is then once you've got all of this, if you can minimize the amount of data you're keeping and mitigate your risk, and if you have a good retention program, then you're not at risk of having to share all of this, especially in the event of a lawsuit or so on. And then lastly, training and communication. If you go through these 7 steps, there is a guide we'll be sending out as well that goes through these in a little bit more detail. But we recommend companies basically look at this 7-step roadmap to getting a good HR compliance program in place.
You know, an interesting question, I just want to bring it up, and it's really for you, Osama. You know, a lot of HR data types here, and an employer could argue, I need all of these to run my business. I don't have to delete it if I'm requested. But is there some data that falls into the gray area? And what do I do about that?
Yeah, so this is with respect to category number 5 and 6 here in terms of the steps. How do you respond to a deletion request? And then also beyond that, even if in the absence of a request, how long are you supposed to keep the data? The answer is there are 8 exceptions to the deletion requirement. So if you get a deletion request, you have 8 exceptions. Chances are for most HR employee data that you need to run your business and that you need for compliance, you're going to have 1 or more of those 8 reasons apply. So you got to keep it. But on the data minimization and retention side of things, you keep data for as long as you are legally required to keep it, for as long as you have the data is relevant to a potential claim that you're going to have to defend, so for the length of the statute of limitations. And you should probably keep data for any other business purpose that you can articulate that for which the data was originally collected. So if you collected it to make sure that you are managing employee performance and ensuring that they're providing the services you hired them for, then you keep it for as long as they're providing that service, meaning as long as they're employed, right? And then you have to determine after that, how long do you need to keep it? It's going to be a decision that you'll have to make with every category of data and for every individual request for deletion that comes in.
Thanks for taking the time out. Steve, let's unpack quickly these so we can get to the guts of this conversation, which is managing third parties and this data minimization issue. Why don't you take us through sort of the really key high points in developing this data asset inventory you're recommending?
Well, data asset inventory, as I said, is foundational, right? And in HR, you're going to find lots of different types of data. Some of it is structured, and for those who are not familiar with structured data, imagine going into like your payroll system, and you'll see a field that says name, and another one that says Social Security. It's very easy to find the data, but it's in a database, and you know where the fields are. But the law doesn't stop there. It also covers unstructured data, so data that might be in emails, right? Or data that might be sitting in a spreadsheet or in a Word document somewhere. So that's unstructured, much harder to find, although there are tools to do that. Of course, Brad mentioned paper records, videos, photos, all of those things count. And why do you need it? Well, you need it for lots of reasons, really. One is you need it because if you get a request in, it's fundamental to compliance. You've got to know where the data is so that you can respond to the request and say, this is what I've captured about you. This is why we have this information, and this is what we intend to do with it and how long we intend to keep it. Of course, there's legal limitations on collection of it, and you've got to have some place where you say, what's your retention policy on this data? How do you manage it? How do you do that if you don't have an inventory, you know where it is? You're going to need it to do your annual policy updates. You're going to need it to reduce your cybersecurity risk, and that's often overlooked. This is where privacy and security really need to work together. If you're going to put together a security plan around your data, you need to know where the most important data is stored, right? Think about it if you're at home, and if somebody were to break into your house, what's the first thing you do after you make sure your family's safe? You go into the jewelry box and say, gosh, did they get my jewelry? And if they did they get my good jewelry or did they get my costume jewelry, right? And you kind of want that inventory, and it's a similar concept with HR. You want to know where it is so that you can take that really good jewelry and put that under a special lock and key somewhere versus maybe the costume jewelry that you'd want to protect, but maybe not quite as much. Data is exactly the same way here. So that inventory is foundational to helping you do all of these things across the board.
How much time would a company need to spend just to do the inventory adequately from your perspective, Steve? Say, I don't know, a $500 million sales company based on your experience.
You know, we do a data asset inventory in about 2 days, okay? It's through interviews. It gets you about 85% of the way there. It's never perfection, right? And getting that asset inventory together, it's a lot of work, it's a lot of data, but it gives you a pretty good sense of where you're at. Now, once you have that, you can peel further and say, now let's go down to the records and put some automated tools in place and so on and so forth. But I think just getting that landscape within about 2 days of our time or so, we can get a pretty good footprint of where that data is. And also, by the way, identify for the legal team, like Usama, what the collection purpose is so that they can, out of that inventory we do, be able to update their policies, and also work with the cyber teams to say, hey, we've classified the data on sensitivity, and this is where the most sensitive data is stored, right? So in about 2 days, you can get a fair bit done if you have an experienced team helping you.
A very common question that I get on this, especially from people in HR, is why do we need to do this kind of detailed data inventory? Why can't you just give us a template for the notice and the policies? Give us a template, and that'll work. Right? This is the expectation from a lot of people, is that it's a plug and play. Will give us a template. The answer is there's not a single template that will get you 100% compliant. And anybody that tries to sell you a template has to make sure that they provide you all sorts of disclosures that the template is not compliant unless if it accurately describes the data you're collecting and how you're using it and other things you have to put in there about your data. So in the absence of a data inventory, if you don't have enough time to meet the compliance deadline, yeah, you can start with a template, eyeball it, have the people who know take a look at it, make some revisions, and then once you complete and start using it, but once you complete your inventory, then go back and update it. But it never should be in lieu of completing an inventory. Take a template and run with it.
Thanks, Usama. Steve, why don't you just touch quickly on securing the data before we get into the guts of managing third parties, if you would?
Well, as I said, breach risks are huge now, right? And especially since the pandemic, anybody's watching the news, a good indicator here, pre-pandemic, cybersecurity insurance was the cheapest thing on the block. These days, about 25 to 30% of companies that apply for it can't get it. Why? Because the underwriters have taken such a bath since the pandemic started on breaches. And if you don't know where your data is, how are you going to protect against an unauthorized breach? So that's why this inventory and privacy and security have to play so closely together. You need to know where it is so you know where you can appropriately protect it. And you also want to know what happens in the event of a breach, how are you going to appropriately respond? Having an inventory, by the way, significantly helps you reduce your breach response costs, because you don't have to know everybody. If you know they got to this server, they only got to these files, and if you have an inventory, you'll know that subset of people you need to notify rather than everyone. And I think Usama and any attorney that's been through this will tell you having that is invaluable cost savings just there alone.
So HR is pretty unique. We really rely a lot on third parties. In fact, the modern organization is using more SaaS than ever to manage data, to manage benefits, to manage payroll. I would say almost 30% of our data, if not more, is out there in a third party. Let's talk about it.
Well, you're absolutely right, Brad.
Go ahead. I was just going to jump in, Steve. Historically, I think HR has been used to sending these full files that we talked about. And I think it's a fundamental mind shift, if you will, to look at how you manage these. I mean, there's a couple of pieces, obviously. One is contractual, making sure that your vendors are only going to do certain things. But I think are your vendors using the latest solutions? And we find ourselves educating our clients pretty frequently that, hey, there are newer ways out there than sending this mass data on a weekly basis or periodic basis. And so how do you manage around that? First is understanding some of it, understanding what your options are. And are there better, newer ways of using, let's say, technology that not only minimizes that data footprint, which we'll get to, but contractually agreeing to limit the amount of data that's being sent. And, Steve, you and Brad work with this every single day in terms of helping clients understand the newer ways of managing, handling data, et cetera. Feel free to jump in on that one.
Well, you're absolutely right, Bill. I mean, the data sharing, especially in HR, is incredible. And I'm always shocked a little bit at how loose it is, right? You've got third parties and you say, okay, what if there's a breach? Who's responsible? Have you looked at that language? No, if there's a deletion request, what's the turnaround? You've got you got to respond in 45 days. Do you have a service level agreement with your vendor on how quickly they're going to turn that around? The data flow is just not really well understood or well managed in my mind. And I think part of the reason is because it's overwhelming. If you go into a company, and especially some of the mid-sized companies we've worked with lately, and you say, look, do you have a list of vendors? And many of them will say, no, I actually don't, because the vendors are all selected by individual departments in the company. So you don't even have a list of people, never mind having the contractual language or having the cyber review to see whether the data that's being shared with them is appropriate and protected, right? So I always suggest get a list together to start with. Get an inventory of your vendors and then start to risk classify them. Don't try to boil the ocean. Go after the ones that are most sensitive first. I like to call them the A's, B's, and C's. Figure out who your A's, B's, and C's are, and we have some methodologies to help companies with that. And then once you do, then Bill, to your point, let's start hitting the A's and saying, these are the ones we're sharing the most sensitive data with. Let's go after them, look at the data flows, make sure we're not sending full files, right? Make sure we're just sending the data they absolutely need. And just because they have an API, don't necessarily send them everything in the API. Just send them the data that you need in the API, right? If they don't need to see your social security numbers, then don't fill that field in the API. You've just mitigated your risk, right? So a little bit more scrutiny around those is what we really recommend. Take a pragmatic approach, peel it apart in chunks, but you have to start managing it. And by the way, the law is going to start requiring that you do that.
Yeah, and speaking of the law, I want to address the legal requirements. What is the law actually requiring? So just back to this slide, the law, as in the CCPA, the California Consumer Privacy Act, and potentially other laws that you're subject to in other states or even federal may require this. But at least with respect to the CCPA, you have an obligation to properly manage the vendors that you have entrusted to collect, process, maintain your employee data and your job applicant data. So your obligation to maintain reasonable security measures flows through to ensuring that your vendors are also maintaining appropriate security measures. In fact, if there's a data breach at your vendor related to with respect to your employee data, and it turns out that that vendor had failed to implement appropriate security measures, and you didn't ask, and you didn't subject them to any kind of review, monitoring, or audit of their security measures, then you may have some liability. And so there's that obligation to do some due diligence on that. Then there's also the obligation to make sure that you have contract terms with all of these vendors, subject to certain exceptions, of course, like vendors that are 100% subject to HIPAA with respect to the data that they're getting from you. There are certain exceptions, but generally a vendor that collects or processes employee or applicant data on your behalf, you got to have some terms in there to address that. And then the third legal obligation is in responding to consumer requests, you're going to have to go back to that vendor and know what that vendor has done with these vendors. And that brings me to a very critical point leading to the next slide for Bill. Is your vendor selling your data? Is your vendor selling or using your data for ways that you don't know, that your employees have not been informed about. So is the sharing of an employee's data with a vendor suddenly going to result in your employees being bombarded with ads from, name a company out there that's sending ads to an employee? And if that's happening, and you haven't asked and you haven't vetted the vendor appropriately, that could lead to trouble down the road, and that could result in some issues in having to comply with the consumer request, as well as with the obligation to tell your employees whether you're selling their data. You're not selling their data, but is your vendor actually selling the data without telling you?
Yeah. So, Bill, you offered the fine print. What is this thing? What is this that we're looking at right now?
Yeah, great question, Brad. So, believe it or not, this is a public statement, part of a privacy statement for one of the largest vendors in our industry. A well-known name. A lot of people on this phone call today probably are utilizing this vendor, and it's just indicating how they're using this data. Now, one of the problems is, Usama mentioned, is a lot of these contracts, agreements, client agreements have been in place for years and years, 5-10 years, and no one's really looked at it. Well, a lot of things have changed during that time frame. Number one, obviously, we're talking about today is some mandated legislation, but every HR department also has the obligation really to protect their employee data, their company data, and evaluate how is my vendor using this data. And so if one of your major vendors is stating in their privacy agreement, these are ways that they've shared and or sold your data that they're collecting, that you're sending them, it should raise some red flags. And I think more than anything, we find ourselves educating the client on this, but now they're really taking a look at it as a result of the legislation, which is positive for everyone. But you need to read beyond just the client agreement to maybe that vendor's privacy statement and contractually agree how you're going to use my data and how you're not going to use my data. So that's part of the equation.
Great segue. We're getting a tremendous number of questions about, really for Usama, how do I control the contracts? What do I need to add to these contract terms to sort of start roping this in?
There are contract terms that are in the regulations that are in effect. There are also contract terms that are in the proposed CPRA regulations that are currently being debated by the new agency. But generally, you're going to have something along the lines of the vendor cannot use or disclose the data outside of the context of the services provided, no exception. The vendor cannot sell the data. The vendor cannot combine the data of your employees with data from others. They can't monetize off of the data. Certainly, the vendor can aggregate and anonymize the data as long as it can't be linked back to the individual for their own purposes, but they just can't use the actual directly identifying data of the individuals. You also need some other contract terms related to compliance with consumer requests that you receive and having to cooperate with you in complying with the consumer requests. And of course, there are others. So I would make sure you consult your attorney, Fisher Phillips or anyone else. We work with clients on setting those contract terms and providing you that data protection agreement that you need for all those vendors.
Thanks. I'm just trying to respond to the tremendous question and many, many people asking it. Thanks for that. Back to you, Bill. How do I claw back control?
Yeah, great question. So one of the things we coach our clients on is to utilize the newer technologies. Steve mentioned APIs earlier. If you're not familiar, application programming interface, which can largely replace the old file feed and storage. The problem is a lot of people will say, yeah, we're using APIs. And as we go to the next, there we go. We really need to be looking at using what we'll call real-time APIs, which is more about one record at a time, eliminate that mass send file feed data storage outside of your HRIS. What can be better to prevent misuse of data breach than not having your data somewhere else? In the modern technology, real-time APIs allow us to, let's say, get a verification in, utilize that real-time API to pull the one employee record back and deploy it without any mass sending of storage. And that's really the benefit to employers, employees. And you know what? They're really pretty easy to set up. So a lot of people say, I don't have the time. Well, you got to make the time now because of legislation, but it's a lot easier than you think. And it's a lot easier to help minimize the data.
Well, and these APIs work both ways, right? It's not just what I'm sending, but it may be that I'm over receiving processed information on my own employees that get dumped in a file and I lose track, right?
Sure, absolutely. Yeah, it's, know what the data set is that's necessary, know what it is you need back, and limit it to that, both contractually and in agreement with your vendors to say, hey, this is kind of crazy. We've created unnecessary liability. And I think here in the next couple of slides, we're going to get to how do we quantify that too.
Great. We've only got about 14 minutes left, so I'm going to pass through the notice of collection piece, unfortunately, Steve. But let's talk about the problem. We've got a lot of rights out there, and we now have to manage consumer requests and now employee requests.
Absolutely, because under California law, employees are now treated just as consumers, so the same rules apply. So you've got to provide a mechanism for employees to request what data you're keeping about them, back to the transparency point. You've got to give them some control of what kind of data you have and also making changes to it if it's inaccurate or deleting it. And you've got a timeline to respond, right? Timeline varies by state, and if it's international, there's different timelines, but nevertheless, this has to be tracked, documented, written down so that you can demonstrate you've been following this process, right? And so all of that, again, is just to help protect that consumer or that employee, same person now, in the process and giving them some control over their data.
What rights do I have to process, Steve?
Well, employees have the right to know what's been collected. They have the right to ask that their data be deleted, right? Now, again, there's some legal restrictions there, right? You have certain retention requirements. There are other things you'll want to do. Work with your attorneys to determine what that means. So it doesn't mean it's carte blanche to delete everything, but it's certainly a right to have their data be deleted under circumstances not controlled by some rules or regulations. They have a right to correct their personal data if it's wrong, right? And request that. They have the right to opt out of the sale or sharing of their data. California defines a sale of data. It really is an exchange of data for some, for some value. And you have the right as an employee to say, I don't want my data to be sold, right? So, for example, to Bill's record there in that policy, right? If the third party is saying, guess what? And you saw it there, I'm going to take that, I don't know, payroll record you sent me, and I'm going to go and sell that to third-party brokers, right, on the back end without anybody knowing about it. The employee has a right to say, nope, I don't want that to happen. I'm okay with you processing payroll, but I'm not okay with you passing it on for other purposes, right? And so that's a right. You have special rights now to restrict and the use and disclosure of sensitive personal data, and that's the category we talked about earlier. California now with CPRA is going to define certain types of data as highly sensitive or sensitive, right? And so you've got to protect that a little bit more perhaps than some of the other data. They have a right to seek damages, and you can't retaliate, right? And I think this is an interesting point here, Usama, you may want to opine on, because I think this is going to be a hot spot for litigators, personally.
Yeah, the CPRA prohibits retaliation against employees for exercising one of their CCPA rights. Employees cannot sue for retaliation under the CCPA. They can only sue for a data breach. However, if you fire an employee right after they submitted a CCPA request, they can potentially try to argue that the termination was retaliatory and bring a wrongful termination type claim under common law. They can also potentially try to bring a Labor Code 1102.5 type of retaliation claim. So that's going to be one area to watch out for. But I also want to comment about the right of deletion and the right to opt out of the sale. Let's just use, for example, a vendor that you utilize for verification purposes, so that you can respond to third-party requests from third parties to verify the employment status and compensation of your employees. If you haven't vetted that vendor properly and you haven't reviewed their privacy policy, like in the example Bill provided, then how are you going to know to go to them and to make sure that they are deleting the data or not using the data for those purposes that you have not been able to disclose or you haven't disclosed to your employees? Right of deletion, for example. If that vendor has been getting a file feed dump every single week from you of all of your employee data, and they still have those prior data dumps, why do they need to have it? Maybe they just need this week's data dump, right? Maybe this week's data dump is what they're going to use for the actual service of verifying the individual's employment status and compensation. But last week's data dump is at this point completely unnecessary and not needed, right? So, and then the other question is, with respect to deletion, is if you terminate the contract with that vendor, are they going to honor your request to delete all data? Have you obligated them contractually to delete the data upon request or to delete the data when the contract terminated? If it's like pulling teeth trying to get them to delete the data, that's a big problem, and that's a vendor you should probably consider and evaluate before you renew the contract, before you even sign up with them.
Usama, all good, and let me just kind of share here. For those who aren't aware, there is a data economy underneath the covers that you may not have visibility to. It's an over $3 trillion industry that trades on data, okay? And so there are financial incentives behind the scenes to share this data and to monetize it on the back end. And that's what some of these laws are trying to restrict, right, is to stop that economy. Now, it's a big push because there's a big economic force behind a $3 trillion industry and a lot of lobbying, right? But when you see these things in the policies, if we have the right to share with a broker or to sell your data to someone else, it's because there's a monetization effect on the back end. And that's the economy that you're up against here in the broader scheme of this privacy challenge, right? So I think these rules are trying to restrict that. But understand it's not just, somebody sending you an ad. It's a whole bigger deal than that behind the scenes.
There's an overlay here in terms of our obligations to minimize the use of our data, to understand it. We've been talking about it, and then to either retain or dispose of it. Steve, you want to introduce this topic, and then we'll segue to Bill, I think, as an expert in this space.
Minimization and retention is key, right? If you can reduce your footprint, then if you have a breach, there's simply just that much less data to be breached, right? There's some legal requirements now under CPRA that Usama can opine upon and explain. But bottom line, it's always been a good idea to minimize the amount of data you have. Data is kind of the new gold. It feeds this economy we talked about that I just mentioned. But at the same time, it's also your new biggest liability, because if there's a breach, my gosh, you've got some huge risks on your side that could really put you under. So you've got to find a balance between both of these. And I think putting some good practices in place are now, the one good thing about the law is starting to force us to do things we should have been doing along anyway, right? And it's just good hygiene that we've been neglecting. And in some respects, this is now forcing our hand a bit.
Bill, I'm not sure I'm convinced. Steve talks about risk, but I haven't been breached yet. People say it's only a matter of time. It's not a matter of if, it's a matter of when. But how do you guys look at risk, and how do you quantify that?
Yeah, great question. And I kind of want to bring in Steve's previous statement at this point where, this law or these series of laws across the country are really finally forcing the hands. I think some people get a little lazy. We got a contract in place. It seems to be working all right. But what's really happening behind the scenes, and, this is just a microcosm of the larger picture you mentioned, but when you look at the amount of data that is not only being stored internally, but really sent externally, to which you have very little control unless contractually you've done what you need to do. So in the verification of employment and income space, just as an example, right? So if I had 10,000 employees and I send my full file every single week to my given vendor, that's 520,000 employee records per year. Now, one of the things we like to do is walk clients through how many of those really needed, let's say, a VOE, VOI in a given year. Well, the numbers probably, depending on your industry and turnover and so forth, maybe 2,000, 2,500 of those employees would need a given verification in a year. So why am I sending 500,000 records, right? Why don't I use the later technology and just send one employee record when I receive consent that the employee has signed it? They've signed a release. They want me to do this for their mortgage company or whatever. Great. So pull the one record and deploy it then. And when we look at the misuse of data, particularly in this industry, it's 15 or 20 times per employee per year. So if you're a vendor saying, oh yeah, you got 10,000 employees, we're doing 150,000 verifications a year for you, you got to sit up and say, well, what? 15 times per employee per year? There's no way, right? And so we walk clients through that data set and say, look, we can eliminate 148,000 of those uses and 518,000 records being sent in a given year unnecessarily. And what that does is twofold. Yeah, go ahead.
Are those vendors receptive to you changing the game? If you don't want to send them 500,000 records in your particular example, or does it force me to look elsewhere?
Yeah. Well, is the vendor receptive? You'll find that most of them are not. You do need to look outside of the, let's call it traditional box, at newer vendors that are willing to use the newer technologies and protect the data rather than monetizing the data. So you mentioned earlier, data is being monetized at an amazing clip right now. Why put yourself in a position where one of your selected vendors would monetize that data? Contractually eliminate it. Don't send the data at all.
So this is a little bit about your balance sheet. I know it's not an actual liability, it's sort of a phantom liability. Are you talking about reducing liability?
Absolutely. So aside from reducing just liability related to CCPA, CPRA, and other legislation, just remove the potential for breach, right? If you selected a vendor, they didn't take the adequate protocols, as Usama mentioned earlier, then you're going to be liable at some point in time, potentially. So if you just looked at some of what IBM and the Ponemon Institute have looked at $180 per record per breach, well, if I don't send 10,000 records a week, 520,000 a year, and I only stick to what is legitimate consented verifications, well, gee, I didn't even touch 8,000 records in a given year, saving me a potential of $1.8 million in liability and a whole lot of other liability associated with legislation. There's a lot of ways we can slice and dice this, and we walk through this with clients to show them what liability really amounts to if you have one of these vendors that might be abusing the data. And that's really what we try to show. And there's multiple ways to eliminate that liability, not to mention, let's face it, the obligation you have, even if you're not in California, your employee base isn't in California, you are obligated to really pay attention to what's happening with your data.
Well, I'm not surprised we're running out of time. Osama, why don't you start us in on our closing thoughts, and we'll go around the horn here.
Privacy compliance doesn't start in HR, so it's an cross-functional team of a lot of people. It takes a lot of time. So if you have not started, you have a team of experts here that can help you. And one of the most important lessons of the day from this presentation, and then I'll turn it over to my co-presenters, is that you are going to be responsible one way or the other for knowing how your vendors on the HR side that you've used for employee data are collecting, managing, using, disclosing, or selling the data.
Bill, your thought?
Yeah, there's a lot of great points in here today. I'm sure a lot of people have to unpack those. Reach out to the experts to help you with it. Reach out to newer vendors that can help you with it. There are people that want to do the right thing, and I'm sure every HR professional out there wants to do the right thing as well. So there's lots of folks on this call today that are happy to help.
Steve, last word.
Data privacy is actually good for business, to be honest. We are consumers. Our data is being used. When we go to work, we shouldn't put a different hat on. Doing data privacy right is the right thing to do. It's good for your consumers. It's good for your employees. And I think it's good for your business. So while this may be overwhelming, it's really not. Once you peel it apart, take it a step at a time. Don't try to boil the ocean at once. Reach out to any of us, and we'll be happy to guide you through these steps. We do this for a living, and I think this takes somebody that specializes in this to help guide you.
Thank you very much, all panelists, Osama, Bill, Steve, and thank you for the folks engaging. We recognize there's so many questions caused by this, and we couldn't possibly have answered all of them, but we'll attempt in some manner to address some of them. Thank you very much, Osama, Bill, and Steve, and thank you for attending. This concludes this webinar. Thanks so much.